Okay, so let's get into the remainder of this program and talk about QME report writing. And our references for this section of the report are going to include the 2001 Physician's Guide and the AMA Guides 5th edition. And what we're going to talk about in this section of the report is how to put your report together so that it's a beautiful work product, and so that it represents you and it represents your hard work and it represents you well. It presents you as a competent and a qualified medical evaluator. And I use the word qualified there differently than what we're accustomed to using it in reference to a qualified medical evaluation. It means that you're qualified, it means that you're competent, it means that you're clear, it means that you're accurate, it means that you're precise, and it shows that you put some thought and it puts some effort into your report. And as I said earlier on in this program, our reports many times outlive outlive us and outlive the case. And you'll never know where your report's going to end up. So you want it to be perfect. Now, I know it's often very difficult, if not impossible, to create a perfect report, meaning not even one single typo. But really, that should be our driving goal, is to create reports that are as close to perfect as possible. And have many, many practical suggestions for you on just how to do that in this section. So we're going to start by talking about the 2001 Physician's Guide. And we'll talk about the required elements that were required of us in our QME report writing prior to 2005, when we adopted the AMA Guides 5th edition. Now, at the time of the recording of this program, which is in 2015, we still occasionally have instances wherein we utilize the 2001 Physician's Guides. But by and large now, we've mostly moved out of the 2001 Physician's Guide and out of the permanent disability rating schedule described in that guide. And we're now almost universally involved with permanent impairment evaluations as those are described in the AMA Guides 5th edition. But the 2001 Physician's Guide still contains many valuable concepts, many valuable ideas, and many valuable elements that we still rely on, because the AMA Guides 5th edition was not specifically written for the workers' compensation system. It's not ideally adapted to the workers' compensation system, especially here in California. So the 2001 Physician's Guide is still a valuable reference, and I'll share with you some of its important and valuable concepts here as we go. So I wonder how many of you have the 2001 Physician's Guide. I have it here for you on screen, and you can see that this is the 3rd edition in 2001. And this is what's called the Physician's Guide. Many of you are familiar with this, but if you're not, this is the Bible that we used to describe the procedures involved with the qualified medical evaluation prior to 2005. So the 2001 Physician's Guide, and the Physician's Guide in general, has a much longer history in the California workers' compensation system than does the AMA Guides. And as I said, this was our Bible, or our set of Bibles, since we had multiple editions. These were our Bibles to govern the QME process prior to 2005. So I want to share with you some of the important concepts that the 2001 Physician's Guide required back in the day, that we include in our QME reports, some of which are still going to apply. And I'll show you how we integrate the elements that are required in the 2001 Physician's Guide with our current permanent impairment evaluations that we do based upon the AMA Guides. So what we're going to do with the 2001 Physician's Guide is we're going to go into chapter 5 and talk about the role of physicians in the workers' compensation system. And we're going to go right to the medical legal reports in chapter 6, writing medical legal reports on pages 99. And then we'll go and talk about some other descriptions on page 110. Okay, so let's dive right into the 2001 Physician's Guide, and we'll return here shortly. Okay, so the 2001 Physician's Guide gives us some guidelines as to what are the elements that are required to produce a well-written or otherwise ratable report. And we'll refer back to the 2001 Physician's Guide itself in just a couple minutes, but for our purposes now, I just want to list out for you in numeric format what it is that the 2001 Physician's Guide required. So item number 1 is they required that we have a section of our report that contained the identifying information. In other words, the demographic information about the injured worker, the insurance company, any attorneys involved, etc. And we'll elaborate more on identifying information here as we go. It required that we have an opening statement. It required that we list our sources of information. We refer to this now as our review of records, and I'll show you how we handle the review of records and how we list our sources of information. They required that we can have a section in our report describe the history of the present illness or injury. They required that we list and describe the present complaints and or present symptom. They required that we have an elaborate and extensive history section that included, number 1, the social history, the review of systems, and any related or relevant medical information. Required that we have a section in our report describing the results of our physical examination, a section on the diagnosis of the current condition, a section describing the causation of the disability in those cases where disability was present, a statement as to whether or not the examinee had arrived at a permanent and stationary condition. It required that we have a section in our report where we describe the factors of disability. Now, for injuries after 1105, we no longer describe factors of disability. Rather, we describe permanent impairments. But back in the day, it used to be called factors of disability. And we're going to see that in our new hybrid style of reporting, we're also going to have this section. But for injuries after 1105, we're going to describe that the permanent impairment section of our report. The 2001 Physician's Guide required that we have a section in our report wherein we discuss the apportionment of the permanent disability. They required that we have a section wherein we describe the current medical treatment needed, if any, the future medical treatment that would be necessary to cure and or relieve from the effects of the industrial injury. Number 15, the reasons for our opinion. And isn't that interesting? This sort of coincides with our discussion on substantial medical evidence, wherein we provided the how and why we arrived at our opinions and conclusions. So even back prior to 1105, the 2001 Physician's Guide required that we have a statement as to the reasons for our opinion, and they required that it not simply be a templated, regurgitated script, that we actually describe the specific citations and the specific passages in the medical records and the specific reasons based on the physical examination, and all the collective reasons that contributed to the opinions and conclusions. And the 2001 Physician's Guide finally required that we provide a disclosure whether or not other individuals were involved in the evaluation, and several other different types of disclosures. And we'll review those disclosures in just a minute. And I just want to ask, for those of you that have been doing qualified medical evaluations for any length of time, meaning before 1105, how many of you are using this format, whether in its entirety or whether or not you're using parts of this format? And my guess is that if you've been doing QME reports for any length of time, your current reports probably still retain some of these elements that are described in the 2001 Physician's Guide, and there's good reason for that. And as I said earlier, it's because the AMA Guide's 5th edition was not designed to be adapted to the California workers' compensation system. Rather, it's designed to provide for permanent impairment evaluations in many jurisdictions, and it wasn't specifically designed for workers' compensation situations specifically, whereas the 2001's Physician's Guide was. And so many of these elements that are required in California workers' compensation are not discussed in the AMA guides, and so we retain many of these elements into our current report writing, even though we're not currently describing permanent disability, but rather we're describing permanent impairment. Okay, so let's go back now to the 2001 Physician's Guide, and let's go to the section in Chapter 6 described as the required elements on page 103. So let's scroll down there to page 103. Okay, and this is, well, actually this begins on page 99. Okay, so we're here in the section of the 2001 Physician's Guide talking about writing the medical legal report, and we're going to talk about the required elements that are described in this text. So we're on to the required elements. Okay, so the AMA, this is the 2001 Physician's Guide. They talk about including identifying information. They talk about an opening statement. And let's just go over a couple of these to describe some of these elements that may not be described in the AMA guides. So with identifying information, it says that the heading of the report should provide the information necessary to identify the report, including the date of the report, the name of the applicant, the date of injury, the claim number, the Workers' Compensation Appeals Board number when possible, and any other information necessary for clarity to the parties. So, for example, the name and address of the claims administrator, the name and address of the applicant attorney, the name and address of the defense attorney, perhaps a picture of the examinee to identify the examinee as an actual person. All of that is included in the identifying information. I'm going to show you examples of how this would look in your QME report here in just a couple moments. Your report should include an opening statement. This section should provide information on the context of the report and the performance of the examination. In this section, you're required to provide the date, the place, and the duration of the exam. You're required to describe the actual time spent face-to-face by the physician with the injured worker. Face-to-face time includes the time in which the evaluator takes the history, performs a physical examination, or discusses the worker's medical condition with the worker. Face-to-face time does not include time spent in the performance of diagnostic or laboratory tests, such as blood tests or x-rays, or time spent on records review or report writing. And I'll show you how to construct an opening statement that complies with all of these requirements, including describing the face-to-face time and in describing the time spent on review of records. Okay, the report should contain a section that describes the sources of information. This section should contain a list of all the medical records that were reviewed in the preparation of the report. You must also record any non-medical information and its source that was received from either party and reviewed in preparing your report or in formulating your opinion. You should list the names of anyone other than the patient who was interviewed or with whom the case was discussed. And nowadays we refer to this as our review of records section. And it's interesting because the review of records section in our report actually is governed by several labor codes and several codes of regulation. And I'll show you how to construct the review of records section of your report so that it complies with all of those requirements and also complies with the requirements as described here in the 2001 Physician's Guide. The report must have a section describe the history of the present injury or illness. And this is the injury or illness that is the subject of the workers' compensation claim. So let's just read some of these requirements. The report must include a comprehensive and factual account of the industrial exposure, the applicant's complaints, and the treatment the applicant has received. And I talked earlier in the program about an efficient and effective way to do this. The nature of the claim will determine how extensive this history must be. Injuries resulting from cumulative trauma or occupational illnesses will require a detailed explanation of the applicant's job duties, the conditions of the injurious exposures, including the approximate time spent on the tasks in question, and the temporal relationship between the exposure and the symptoms. The history for a specific injury should describe the activity that immediately preceded the accident and how the accident occurred. And we refer to this, and let's create a footnote right here. We refer to this is what's called the mechanism of injury. Mechanism of injury. And you should spend extensive time in determining the mechanism of the injury, because it's the mechanism of injury that you're going to rely on later on in your report when it comes time to provide opinions and conclusions, especially on the causation and apportionment of the permanent impairment. So mental note here that extra emphasis is placed upon the activity that immediately preceded the accident and how the accident occurred. We refer to that as the mechanism of injury. So they elaborate on that here in the 2001 Physician's Guide. They say that whenever possible, you should provide relevant details, such as the approximate weights of objects, the worker's position while performing the task, the height of a fall, and all specific and detailed information that fully elaborates on the mechanism of injury. Your report should describe what happened after the injury. Were they transported by ambulance to a hospital? Did they continue working? In other words, in the history section, you describe the history of the injury, the history of the medical treatment, the history of the symptoms from onset, meaning from the date of the injury, all the way up to present time, immediately preceding the date of your evaluation. Finally, if there is more than one injury, the report should clearly describe each injury and the subsequent treatment, or changes in treatment if treatment was ongoing at the time of the second injury. Your report must list a section that details the present complaints, or we might title this, instead of present complaints, we might title this present symptoms. Present symptoms, I think, is a more neutral and politically correct term. So in this section, you should explain the patient's current symptoms. You should attempt to relate the frequency, duration, and intensity of the complaints to specific activities and note temporal patterns, such as stiffness in the morning or pain that increases throughout the day. Pain that interferes with activity is a rateable disability in workers' compensation, so it's important that the report give a clear understanding of the extent of any limitations. Now, this is specifically referring to injuries prior to 1/1/2005, when we had different descriptions for pain than what we use with the AMA guides. Now, this statement is somewhat correct in referring to the 2005 AMA Guides 5th edition, because pain we can provide for permanent impairment due to the added burden of pain in Chapter 18 of the AMA Guides. So, regardless of the date of injury, it's important that we provide very specific and clear descriptions of the pain, because regardless of the date of injury, it's possible that the examinee could qualify for either permanent disability and or additional permanent impairment due to any pain that they may be experiencing. Okay, so that's the history section. I'm sorry, that's the present complaints section. Then in a separate section entitled History, this section should summarize important medical events or conditions that may have bearing on the applicant's injury. We might refer to this as the relevant medical history in order to distinguish it from the history of the present injury or illness. So in this section, we would have also a social history, we would have a review of systems, and any other relevant medical information. This is where you would question the applicant about any pre-existing injuries or conditions in the affected part of the body that is the subject of the workers' compensation claim. And earlier in the program, I gave you some suggestions as to how to elicit the relevant medical history. Okay, next section is the physical examination and the findings of the physical examination. Now, of course, this is the main body of the QME report, and this is the section of the QME report over which we as doctors have absolute domain. The physical examination section of our report is the section where we shine as the medical evaluator. So it's my opinion, and I stated this earlier in the program, that your physical examination section of your report should be a masterpiece. It should be clear. It should be precise. It should show exact measurements that are formatted in charts and tables and with bullet points. And it should be clear to non-medical readers. Now, for dates of injury prior to 1/1/05, we used a different Bible for our guidance on the physical examination. We used the Evaluation of Industrial Disability by Packard Thurber. We no longer use that. We now use the AMA Guides 5th edition, and they specifically stated prior to 1/1/05 that you should not use the AMA Guides because the AMA Guides outlines different measurement techniques than those used in California, although California has now adopted the measurement techniques described in the AMA Guides. But if you're evaluating dates of injury prior to 1/1/05 and you're required to use the 1997 Permanent Disability Rating Schedule rather than the AMA guides, you will need to be familiar with the measuring guidelines described in Packard-Thurber. Describe the purpose of clinical tests rather than referring to the test only by name. So don't list the findings of tests by, for example, Kemp's test was positive. You would not say that. You would not say that Milgram's test was negative. You would describe the purpose of the test. For example, Kemp's test is a test that has as its purpose to load and test the intervertebral facets, joints of the spine. So, for example, you might say facet compression test. Facet compression test was negative. Or sciatic nerve stretch test was negative, rather than using the term Lassaig's test. And so, in other words, describe the purpose of clinical tests rather than referring to the tests by name. Now, it says that in this section, if you have performed or reviewed any diagnostic tests, such as X-rays or EMG, you should summarize the findings in this section. We're going to see that when we create our hybrid format of QME report, we're going to have a separate section specifically for diagnostic tests, because I'm sure you'll agree with me that most times by the time the examinee gets to the qualified medical evaluation, they've had many types and even repeat diagnostic testing, including X-rays, MRIs, CT scans, electrodiagnostic studies, perhaps ultrasounds, and all these different types of studies, arthrograms and myelograms. And so the diagnostic studies we're going to separate out and isolate in their own specific section to make it easy for the reader to locate and to summarize the results of all the diagnostic studies. Next, we include a section entitled the diagnosis, and this is where you give a specific diagnosis for each and every condition you are evaluating. And with regards to the AMA Guides 5th edition, I'll give you some suggestions as to how to fashion your diagnosis so that your diagnosis aligns and coincides with your description of the permanent impairment. You should have a section that describes the cause of the disability. We might refer to this in our report as the causation section. So let's call this causation section of the report. Okay. This section addresses the relationship between the conditions you found on examination and the injury or occupational exposure. In some situations, this section can be quite brief. More detailed discussions is required in cumulative trauma cases, occupational illnesses, stress claims, or in cases where additional body parts or systems have become affected since the original injury, and this happens all the time in the current climate of the QME evaluation. We're seeing the addition of psychologic injury, and we're seeing the addition of additional body parts or systems in addition to the principal injury. So the causation section, at least in the current environment, is a section that has the potential to become quite lengthy and quite complex. And for that reason, the causation of the disability or the causation of the permanent impairment qualifies as one of the complexity factors under CCR 9795 and allows for a higher level of complexity of the report and a higher level of billing for the report when the report qualifies as a complex report. So it's my opinion that the causation section of your report is something that you should be very familiar with. Be very familiar with working in this section. You should be very familiar with describing the causation of the disability. And this is a section of your report that you're going to want to be a masterpiece. You're going to want it to be very thorough and very accurate. And you're going to want your opinions on causation of the disability to qualify as substantial medical evidence. Okay, so this important section of the report should include an opinion on or a section on the permanent and stationary status. And it's interesting, it says that in this section you should state whether or not you have determined the patient's condition to be permanent and stationary, along with the reasons for this determination. Isn't that interesting that we have inferences and implications? I guess this would be an implication as to substantial medical evidence all the way back here in the 2001 Physician's Guide. And isn't that exactly what they're asking? They're asking us to explain the how and the why we feel that the examinee may have reached a permanent and stationary condition. Or if the examinee has not reached a permanent and stationary condition, explain the reasons why. Why are they not permanent and stationary? And explain your reasons in a clear and well-formatted fashion. And I suggest the use of listed bullet points so that the reader of your report can clearly see each of the reasons as to why you arrived at your conclusion. The report should contain a section entitled The Factors of Disability, wherein you describe the subjective factors, the objective factors, the work restrictions, and the estimate of loss of pre-injury capacity. This, of course, relates to injuries before 1105. And in our current reports related to the AMA guides, we're going to title this section Permanent Impairment. Okay, and I'll talk a little bit more about that in just a couple minutes when we get into the AMA guides. Your report should contain a section on the apportionment of the disability, and we're going to sort of hybridize this as well to coincide also with our causation section for injuries after 1105. But it's important to remind ourselves that apportionment of the disability describes the degree to which any permanent disability is due to pre-existing conditions or underlying disease. Apportionment applies only to permanent disability. Apportionment does not apply to medical treatment. It does not apply to any of the other benefits associated with workers' compensation. It only applies to the benefits related to permanent disability. And we'll talk more about some current ideas related to the apportionment of permanent impairment to causation when we get in our discussion of the AMA guides. Okay, and then just a couple of more sections. We should have a section of our report entitled the medical treatment that's now needed to cure or relieve the effects of the industrial injury. That is when you feel that the examinee is not at permanent and stationary condition or has not yet reached maximum medical improvement. If the examinee is at a permanent and stationary condition and you provide for a permanent impairment or permanent disability factors, or a permanent impairment rating, I should say, there needs to be a section in your report entitled the future medical care or future medical treatment. This is where you elaborate what type of treatment could be necessary to cure or relieve the effects of the industrial injury, or to cure or relieve any flare-ups or exacerbations as they may arise. And then finally, after all of that is done, there's still some work that needs to be done. You need to have a section in your report wherein you describe the reasons for your opinion. And here it's so fascinating. It says that for each opinion, you must provide a clear description of why you have reached that opinion. You should also provide explanations for any unusual findings. This should be done throughout the report in the appropriate sections. And isn't that fascinating? And I've reiterated this time and time again. Now, it's interesting because the Escobedo case described substantial medical evidence as relating to specifically our opinions on permanent impairment and our opinions on the causation and apportionment of the permanent impairment. But here in the 2001 Physician's Guide, it says that this should be done throughout the report in the appropriate sections. So what that means is that for every opinion and conclusion that you offer, you need to have support for that opinion and conclusion. And you could simply state in sentence format, my reasons for this conclusion include colon, new line, numeral 1, state your reason. Numeral 2, state your reason. Numeral 3, state your reason, and have as many numerals and as many reasons as you have and as it takes to properly substantiate your opinion or conclusion. And doctors, opinions and conclusions without the reasoning behind the opinions and conclusions are worthless. They're meaningless. They cannot be used. It's what's described as conclusory opinions. So you should check and double check your report thoroughly for any unexplained or any unreasoned conclusory opinions. It was described all the way back in the 2001 Physician's Guide, long before we even had the Escobedo case. And it says here, isn't this amazing? A medical legal report that does not contain the reasoning behind the medical opinions reached is worthless in the workers' compensation system. Isn't that amazing? I bet if there was a footnote here, which there's not, but I bet we could go to the footnotes or the bibliography of this book, and this would probably reference the Zemke case, which we stated came about, I think it was in the 1970s. Well, this guide was written in 2001, so probably this is a derivative directly from the Zemke case. Okay, so after we have the reasons for our opinion, we then include disclosure of other individuals involved. There's a mandatory declaration, there's our signature, and there's our disclosure of any significant financial beneficial interest. And I want to go over these sections here in some detail because these are still required with our current QME reports. And these are sections that are not described and in no way have anything to do with the AMA guide. So I want to review these disclosures with you, and then we'll go up to our QME report template, and I'll show you how each of these components is formatted and how it's laid out in an actual QME report. So one of the disclosures is that you must disclose the name, the qualifications, and the roles of other individuals who participated in the evaluation by performing such tasks as taking and outlining the medical history, such as reviewing and summarizing medical records. And doctors, this is where many doctors do not comply with this requirement. Many doctors use third parties, they're referred to as historians, to review and summarize the medical records, but nowhere in the report do they disclose that these other individuals were involved. So it is required. Anyone who administers diagnostic studies has to be disclosed. Anyone who drafts or edits any part of the report is required to be disclosed. says that a violation of this provision can result in your suspension or termination as a qualified medical evaluator. Labor Code CCR 4628. All reports must have the following declaration in its entirety in every medical legal report, whether that be the initial QME report, supplemental report, follow-up reports. All must contain the following declaration. I declare under penalty of perjury that the information contained in this report and its attachments, if any, is true and correct to the best of my belief and knowledge, except as the information that I have indicated I received from others. As to that information, I declare under penalty of perjury that the information accurately describes the information provided to me, and except as noted herein, that I believe it to be true. Signature. The report must be signed by the physician who prepared the report under penalty of perjury. If you sign the report, you must have examined the applicant, taken the applicant's history or reviewed with the applicant an outline of the history. You must have reviewed the medical records and composed and drafted the conclusions of the report. Include the date and county where the declaration was signed. Finally, your report must disclose any proprietary interest or co-ownership you have in any laboratory, pharmacy, clinic, or healthcare facility you used in the evaluation. And this most frequently relates to co-ownership in diagnostic testing facilities, such as imaging facilities. QMEs and AMEs are generally prohibited from most self-referrals, with some exceptions. Your report must contain the statement that you have not violated Labor Code Section 139.3 in that you have not made an illegal referral. Violation of this section can result in your suspension or your termination as a QME. Okay, so doctors, that's a lot, and that describes the required elements as they were described in the 2001 Physicians Guide. Let's now go into the AMA guides and see what the AMA guides requires as far as a clear and concise permanent impairment report. And then what we're going to do is we're going to combine the two formats. The format as it's described in the 2001 Physicians Guide and the format as it's described in the AMA guides. We're going to come up with a hybrid format that touches and covers all the bases required, number one, by the AMA guides for permanent impairment evaluations, and then number two, that are required in the California Workers' Compensation System that may not be described in the AMA guides. Okay, so let's talk now a little bit about the AMA guides. Okay, so let's go to the AMA guides and see what the AMA guides requires, at least in terms of preparing permanent impairment reports. So this is from page 21 of the AMA guides. Section 2.6 says a clear, accurate, and complete report is essential to support a rating of permanent impairment. And you'd be surprised how many doctors' reports that I review are not clear. They're not accurate. They're not complete. They're not internally consistent. We're going to talk about all of those elements here as we go. The following elements in bold type should be included in all impairment evaluation reports. Other elements listed in italics are commonly found within an IME report or may be requested for inclusion in an impairment evaluation. And we're going to talk about how to integrate the elements that are commonly found in a QME report with the elements that are required for the permanent impairment report. Okay, and so the AMA guides, and this is on pages 21 through 23, I believe it is, talks about a narrative history, work history, and you'll notice here in the AMA guides, they put work history in italics, meaning that it's not required for an impairment evaluation report. but in California workers' compensation, work history is required. So this is important because it highlights some of the distinctions between what the AMA guides were originally intended to address and how we've tried to stuff an apple into an orange or a round peg into a square hole by stuffing the permanent impairment report and the AMA guides into the California workers' compensation system. And so let's go over each one of these elements that are described here in the AMA guides. Okay, so the AMA guides require that we have a section in our report entitled The Narrative History, with work history being optional, but we'll talk more about that in our hybrid format in just a minute. They require that we elaborate on the current clinical status, and that includes what they describe as the chief complaint, the review of systems, and the physical examination. And you'll notice here that I've put review of systems in bold, and I want to emphasize the review of systems because I found that not many doctors actually perform a good or any review of systems. And I believe it to be important because the AMA guides state specifically on page 18 of the guides, they say that the physician needs to ensure that the examinee understands that the evaluation's purpose is medical assessment, not medical treatment. So we're not there to provide medical treatment. We're there to perform an assessment to determine their current condition, specifically as relates to the presence or absence of permanent impairment. However, if new diagnoses are discovered, the physician has a medical obligation to inform the requesting party and the individual about the condition and recommend further medical assessment. And this is particularly appropriate. Specifically, I can cite at least one case in my own experience where my physical examination uncovered an examinee who had the early stages of Parkinson's disease. Now, the Parkinson's disease obviously was not caused by the industrial injury, but the individual simultaneously had the development and ongoing progression of Parkinson's disease. And I discovered it during physical examination. He thought that perhaps his symptoms were related to the industrial injury, but I attributed those symptoms to something different, to some different type of neurologic disorder, and it turned out to be Parkinson's disease. Well, we were able to get him an assessment, at least under the industrial injury, for these strange symptoms, which turned out to be non-industrial in nature. But we helped this individual to obtain proper medical treatment for a health condition that certainly was at least as important, if not more important to him than the industrial injury. So I want to encourage you to integrate and implement a good review of systems in your standard procedure. AMA guides require that we include a section entitled the Diagnostic Study Results. They require that we report on maximum medical improvement of the condition. And we're going to hybridize the concepts of permanent and stationary with maximum medical improvement in our hybrid format. They require that we have a section entitled the Diagnoses and the Permanent Impairments. And it's important that the diagnoses correlate with the permanent impairments. Many doctors put down diagnoses that have no connection or no relationship or no consistency with the permanent impairments that's described by the doctor. And this is a report writing inconsistency. The diagnoses and the impairments should be consistent. We're required to describe our impairment rating criteria. We're required to describe our impairment rating. And then we're required to calculate the permanent impairment rating and explain how and why we arrived at a particular permanent impairment rating. So like we did with the 2001 Physician's Guide, I want to ask you, how many of you doctors are using this format in its exact description? Probably not many of you, because we don't use this exact formatting here in the California Workers' Compensation System. But there are parts of this suggested report writing format that we can integrate into our hybrid QME template to include the important elements, specifically as relates to the permanent impairments. And I'll show you how just such a report will look in just a couple moments. So you'll notice here I have a table for you wherein we sort of compare the 2001 Physician's Guide with the AMA Guide's 5th edition. And you'll notice that the requirements of the AMA Guide's 5th edition is substantially less than what is required by the 2001 Physician's Guide. And we already alluded to the reason as to why, and that is because the AMA Guide's 5th edition is not intended to address workers' compensation issues. So you'll notice also that the Physician's Guide and the Guide's 5th edition have some components that are roughly the same and or similar. So for example, I have here highlighted in light blue, under the 2001 Physician's Guide, we have a section of our report entitled The History. Well, the AMA Guide describes that as the narrative history and or the work history. So we're going to sort of adopt the two formats and create a hybrid format. But what we're going to do is we're going to separate out the work history from the history of the current injury and or condition. You'll see that here I have highlighted in red that the 2001 Physician's Guide talks about the history of present illness or injury. Well, that's roughly similar to what the AMA Guides describe as the current clinical status, wherein the chief complaint, the review of systems, and the physical examination is described. So we're going to sort of hybridize those headings as well, although of course we're going to separate out the physical examination from the chief complaints and the history of present injury or illness. In California Workers' Compensation, we talk about permanent and stationary, whereas the AMA Guides refers to maximum medical improvement, and those are separate and distinct types of issues, but they're closely related, and I'll show you how we hybridize and combined those two ideas into one section of our report. And then finally, whereas the 2001 Physician's Guide has a section where we describe the factors of disability, in the AMA Guides, we're going to talk about the impairment rating for injuries after 1105. So let's go in now to our sort of hybrid format that includes all the elements required by both the 2001 Physician's Guide and also by the AMA Guide's 5th edition. And we'll elaborate on each of these a little bit more as we go, and specifically when we get to our QME template where I show you how all of this gets formatted into a clear and cohesive report, we're going to elaborate extensively on number 1, the identifying information, number 2, the opening statement, number 3, the history, 4, the relevant medical history. We'll go over extensively number 6, the review of records, and then also we'll talk about activities of daily living and symptom questionnaires. So these are all elements that we're going to include in our current report writing template to cover all dates of injury, both before and after 1105. We're also going to include a section where we talk about the occupational history. The AMA Guides refer to that as work history. We're going to have a section entitled the review of systems, We're going to have a section entitled the Claimant Report of Symptoms. And isn't that a much more politically correct term than is claimant complaints? I think report of symptoms is much more politically correct, because the claimant is going to report to us what their physical symptoms are as relates to the industrial injury. We're going to have an extensive section entitled the Activities of Daily Living Assessments and Symptoms Questionnaires. And this is an interesting section because nowhere in the 2001 Physician's Guides are we required to report on activities of daily living, except to the extent that pain or the examinee's subjective factors of disability may interfere with various activities. On the other hand, the AMA Guides is all about activities of daily living. In fact, the entirety of the concept of permanent impairment is related on adverse impact on activities of daily living. So we're going to have an extensive section, a thorough section, and a masterpiece of a section of our report that deals with our assessment of activities of daily living. And I've reported on this in other QME home study continuing education programs and courses. So if you have not heard this discussion now, you can find a complete course on activities of daily living on my website, which is www.ezqmeceu.com, or you can find videos on this procedure exactly as I teach it on YouTube. So you would simply go to YouTube and type in Perry Carpenter DC, and there's several videos there as to how to perform an activities of daily living assessment in the face-to-face evaluation with your examinee. We're going to also have a section in our report entitled the Physical Examination, of course. We're going to have a section wherein we report separately on the diagnostic studies. If any medical research is required, we'll have a separate section so that that stands out as a separate and distinct part of our report. We'll have a section on diagnosis of current condition. We'll have a couple of sections on causation, depending upon the nature of the report. As you know, causation refers to both the AOE, COE, and that is whether or not the injury arose out of employment or occurred in the course of employment. So that refers to really the presence or absence of an industrial injury. In other words, an injury that's compensable. Well, we'll also have another causation section, and we'll talk about that in just a moment. We'll have a section wherein we describe the permanent and stationary / maximum medical improvement status. We're going to have a section of our report specifically devoted to the permanent impairment. And as I said earlier, for injuries prior to 1105, we will use the title Factors of Disability rather than the title Permanent Impairment for this section. We're going to have a section where we calculate the impairment rating and describe our methodology in arriving at the permanent impairment rating. We'll have another section on causation. If indeed we find the applicant to be permanent and stationary and suffering from some degree of permanent impairment, we'll have a section wherein we describe the apportionment of the permanent impairment based upon causation. So in this circumstance, the causation related to AOE, COE would probably not be an issue, because by this point in time, the industrial injury has already been admitted and has been accepted. But we'll still discuss the causation of the apportionment of the permanent impairment. We'll have a section wherein we describe either further or future medical care, depending upon whether the applicant is indeed permanent and stationary or not. Then we'll finish up our report with a section on the work status or any work restrictions that may be appropriate for the examinee. And then, like we did with our 2001 Physician's Guide, we're going to have all of the mandatory disclosures and mandatory declarations that bring our reports in compliance with all of the labor codes and codes of regulation that govern these reports. Okay, so let's break down some of these sections and go into these in detail, and then I'll show you how these sections would look in your actual QME report.